SJC-12487, Buffalo Water 1 LLC v. Fidelity Real Estate Company LLC.
Thanks. I'm sorry.
Mr. Bransky, good morning.
May it please the court, Your Honors, Richard Briansky on behalf of Buffalo One Water LLC. By adopting a standard of judicial review for an appraisal that ignores allegations of bias, favoritism, or prejudice, and instead elevating finality, the Superior Court made an error. This is because the elementary right of impartiality is not suspended because parties, sophisticated parties in this case, elected an alternative form of dispute resolution, being an appraisal. Neither of these two sophisticated parties would have voluntarily entered into a contract, delegated authority to a third party if there was the impression that the decision was not going to be based on facts, but rather favoritism.
Well, you say that. Is there any, your brother says there's no allegation that Mr. Skinner actually knew about the contract between Fidelity and Cushman.
Well, one, we didn't allege that Mr. Skinner provided the appraisal. We alleged that Cushman in Wakefield provided the appraisal.
Well, but Skinner did the appraisal, didn't he?
That's correct, but if you look at the specific representations made by Skinner, he uses the term "we." And we hired Cushman in Wakefield, and you review through the specific engagement documents that Cushman in Wakefield was going to provide this specific appraisal.
Well, where in the, I mean, well, first of all, am I correct that there's no, right now we have no information that Mr. Skinner knew of the arrangement between?
We don't know one way or another, Your Honor. We made allegations. This was a motion to dismiss.
Well, I understand, but without that, how could Mr. Skinner's appraisal be affected by a contract unless he would have known of that contract?
It's the appearance of bias, Your Honor. This is exactly what was recognized in Commonwealth First Codings. You don't have Commonwealth Codings. This is the appearance where there is a potential significant financial relationship, that there is the potential for bias. You don't have to show actual bias, which is what Fidelity has continued to maintain and what the court found. In fact, there's a bunch of cases where it says showing actual bias is virtually impossible. There's a Second Circuit case, and when they were trying to factor what the specific formula should be.
Are you alleging fraud or corruption or dishonesty or bad faith here?
We have alleged fraud in the sense that they failed to disclose and affirmatively, we argue, concealed their relationship with Fidelity, which would have impacted, and this is more a challenge on the procedure rather than the substance. And this is similar to an arbitration where the attack is not on the substance of the decision, but rather the procedure, and the failure to disclose impacting the ability to accurately select an appraiser.
But
The
the exact standards that we're applying, because we're dealing with very sophisticated people in a, I mean, there's an inevitable intersection of interests. I mean, it's hard to imagine that when you're dealing with something as large as Fidelity and this other company and Cushman, that there's not going to be some contacts out there besides the ones we're dealing with, aren't we? I mean, it's sort of unrealistic.
Absolutely, Your Honor, but that's not what we're suggesting.
But then let me go to the next step. So what you contracted for, there are three levels. There's the actual hiring of the appraiser, the way there's no conflict of interest provision in the way it's structured, right? The conflict of interest only comes in through this letter, right? The letter that addresses potential conflicts right at the end.
Well,
That's the only
the option agreement doesn't mention anything specifically about conflict of interest.
Right, that's what I'm trying to get at. So the
that's
option,
correct, but if you read through, I mean, sorry.
bear with me, I won't cut you off. I'm just trying to set the stage of where the ethical standards they agreed to are here. From what I understand, the only one we're really dealing with is the letter that addresses conflicts of interest. Conditions of engagement states the appraisal prepared pursuant to the engagement was prepared in accordance with the uniform standards of professional appraisal practice which includes this Code of Ethics 3.6, right?
That's
Is there anything else expressly stated? Because, just general bias and potential for bias, these guys know what they're doing. They're out in the real world. They've set a standard, right? Is this the standard we should look to?
Well, in terms of disclosure,
In terms of ethical behavior, is there anything expressly required besides that here?
well, there's an express representation in this engagement, independent of that ethical obligation, that says affirmatively that Cushman has its own internal conflict mechanism
Right.
and is going to actively disclose that information. I mean, that's the impression a reasonable
Where's that-
person would have when they
where's
review
that
this
lang-
document.
Where's that language? Because I just want to make sure I'm reading is that the disclosure provision is required disclosure of prior services, namely,
It's
that-
it's a few places in the appendix, but specifically it's appendix page 147.
and what does that say?
It's under conflicts of interest. It says C&W adheres to a strict internal conflict of interest policy. If we discover in the preparation of our appraisal a conflict with this assignment, we reserve the right to withdraw from the assignment without penalty.
So with this assignment, if my memory is correct, the Cushman and Wakefield relationship with Fidelity didn't involve appraisals in the past.
I don't know what that relationship involved. There's
But
been,
if it didn't, I mean, you have to allege in your complaint something that at least has the appearance of bias. Maybe the standard isn't that high, but you have to allege something, and if my memory is correct, that Cushman's previous involvement with Fidelity didn't involve an appraisal, then is the engagement letter not being complied with?
to me, it's the appearance of bias. Whether there's an existing commercial relationship between the appraiser or the appraisal company and one of the parties to the appraisal.
Well, even if it is, I think Judge Sanders makes her point, and we've got previous case law and analogies to standards for arbitration, but even if it is, does it have to be something, going back to where Chief Justice Guillen started, that Robert Skinner knows about this, that Cushman and Wakefield are going to be thinking in terms of a conflict relative to appraisals? Does something have to be in the complaint that suggests that appearance of bias?
And that is dependent on the standard that you're going to apply, but here it's the integrity of the process, and there's certainly no harm in the specific full disclosure, whether Skinner, this is Cushman and Wakefield, obviously because they put in their engagement letter that they are going to they have an internal conflict process, there is a reasonable expectation that they're going to disclose a relationship with one of the parties. Ultimately, what we're suggesting, what has been suggested throughout almost uniformly by different courts, is that the disclosure is imperative because it allows the parties ultimately to determine how that's going to impact the process. And that's a disclosure they should be entitled to, first based on the terms of the contract, but second based on common law. I mean, that's a reasonable expectation of the parties that there should be some minimal disclosure of a potential bias. That prevents collateral attacks, which would happen after the decision is made. And I think that reasoning, which is in Commonwealth codings by the Supreme Court and has been repeated almost uniformly, that there's no potential prejudice whatsoever with the disclosure of potential conflict. We can ultimately have discussions as to how extensive that will be, and that depends on the particular standard that you're going to elect. But what is the prejudice? What is the impact of specifically disclosing a potential conflict?
Well, the agreement speaks about prior services disclosure. It says the USPAP, which I guess is the appraisal rules, requires disclosure of prior services performed by the individual appraiser within the 3 years prior to the assignment. And it then represents the undersigned appraiser has not provided prior services within the designated time frame. Are you saying that that's not true?
I don't know whether
Is there any allegation that that's not true?
there's no allegation that that's not true, but if you read the certification that's ultimately signed when the appraisal is submitted. First, the appraisal is not submitted by the individual appraiser, it's submitted by Cushman and Wakefield. It says prepared by Cushman and Wakefield. If you read the limitations, it says the appraiser is Cushman and Wakefield. They're the ones who are producing the appraisal report. And lastly, when Skinner signs that certification at the end, making these express representations, there are provisions where Skinner says, yes, this is me, and he also uses the term we, meaning both me and Cushman and Wakefield.
But the Appraisal Foundation has frequently asked questions, and let me read you one which describes it. Question: if the firm that employs me as an appraiser has provided leasing or property management services in the past 3 years for the subject property, actually for the subject property, must this be disclosed? Answer: not necessarily. The ethics rule requires disclosure of services provided by the appraiser. However, if an appraiser, I think referring to the individual appraiser, believes that the provision of a service by the appraiser's firm or other related entity may be relevant, he or she should disclose that information to a potential client. So that's a rather precise set of obligations focused on the particular property and on the knowledge of the individual appraiser.
But if you read the rule itself, it says direct or indirect, and arguably if you're working for a company that is involved and has an active relationship with a party to the appraisal, that should be disclosed. And that's not definitive. It says not necessarily.
Right, I understand.
But here, if you read the engagement letter, and if you're not, it's a reasonable assumption to make that you hire Cushman and Wakefield. That Cushman and Wakefield is going to hire an appraiser, but ultimately the appraisal is being produced by Cushman and Wakefield. That's what we alleged in the complaint. And it's that Cushman and Wakefield would have the obligation to disclose any conflict of interest. And here, this is a material conflict of interest. And at a minimum, it should.
But I guess, going back to Justice Kafker's question, we're dealing with big boys and girls here. Fidelity versus a property firm. You do have a agreement. You do even set forth required disclosures, but there is no required disclosure of the type that you have described.
I disagree, because
Where can I find
well,
it?
we just talked about the ethical obligations that are incorporated in the agreement
The
itself.
conflicts of interest basically says Cushman and Wakeman reserves the right to withdraw. It doesn't say that it voids the agreement or that speaks about what Cushman and Wakeman can do.
But the appraisal agreement expressly incorporates the code of ethics of the Appraisal Institute.
And that's where I'm trying to find, where in the code, identify for me any provision in the code that says that this is, that the interaction, the relationship between the National Cushman and Wakeman and Fidelity would be in violation of the code. I can't find it.
Not in violation of the code, that it would have to be disclosed.
Okay, where is the disclosure required by the code?
3.6, it says the valuer shall. It talks about valuer and appraisal, and everyone has assumed that the valuer and appraiser is Mr. Skinner. But here, if you read the document itself, the engagement letter, Cushman and Wakefield, this is an appraisal that was prepared by Cushman and Wakefield. That's what it says.
So the Cushman and Wakeman are the valuer under that definition?
That's what we have claimed in the complaint.
Well, I'm just curious, what does the Code of Ethics define that in any
It says
way?
the person who produces the,
Well,
I'm
that goes-
paraphrasing here.
But that goes against you, right? Because the person is, the word, if a valuer has any personal interest in the subject or outcome of the service.
So, so one who is expected to provide a service in an unbiased and competent manner.
Right.
And here, if you read the document itself, this is an appraisal that was produced by Cushman and Wakefield. It seems you wouldn't really get to the impact of the appraisal when Cushman and Wakefield is the one who's going to have all the relationships. If the court has no further questions.
Well, let me just make sure I understand your position. So your position is that if any appraisal firm has any substantial business relationship with one of the parties seeking an appraisal, that there must be a revelation of that business relationship.
There must be a disclosure. Correct.
And that in the absence of that, what happens?
There's the potential bias. I mean, that's what all the cases
So,
talk.
and does it matter whether the individual who's doing the appraisal even knows of this arrangement? Or is that
No,
not?
because to me, it's an objective standard, and it's whether an objective person would think that this information may potentially impact or bias the appraiser.
And why would an objective person believe that an appraiser, individual appraiser, would be influenced by a relationship that he or she does not know about?
Because it could at least give the appearance of bias.
So if,
Go ahead, please.
so if board members, some of the big shots in one of these places, they're on boards together, is that a potential conflict of interest? One of the leading managers of each one of these places, they're on a common board somewhere. Or, because when we start sort of dealing generically with conflict of interest, we got all kinds of subtle distinctions, right? Would that be enough?
I'm just suggesting.
Or if Fidelity, the executives had Fidelity accounts, is that enough?
The suggestion is that it's better to disclose than remain silent. And the incentive in this rule is to remain silent.
So if anyone at Cushman and Wakefield had a Fidelity savings account, is that a disclosable event in your view?
Not in my opinion.
Why not?
This is not material. But if there's a significant financial relationship here, there's an allegation that there's an existing commercial relationship between, we don't know what the extent of that relationship is. And arguably, I think a reasonable person would think there's bias if Cushman is making $1 million, $2 million, $3 million a year from that relationship. That's a significant relationship, and that's something that should have been disclosed at the time that they got the retention. And there's no harm. What is the harm?
Even if Mr. Skinner is not a principal in the firm and has no knowledge of that, and he's the one doing this?
Again, I don't know what Mr. Skinner knew or didn't know. I'm not in a position to make that assumption, and I don't know what he did to run his conflicts to determine whether it was a direct or indirect problem. I mean, that's the problem. We're on a motion to dismiss standard. We've alleged that there's a relationship. We don't know what the extent of that relationship is, and we believe we're entitled to discovery to determine what the nature of that is. And we've been closed off altogether, because that is potential prejudice if there's a significant relationship. And I don't know whether Skinner knew or didn't know, but ultimately if we find out Skinner knew or could have made an effort to find out, then that's something that we should be entitled to at the inception rather than at the completion.
Okay, thank you.
Thank you.
Mr. Apfel?
Good morning, Your Honors. May it please the Court, David Apfel on behalf of Fidelity Real Estate Company. Let me begin where Mr. Briansky started with the contract, with the operative contract. The engagement letter between Cushman and Wakefield and the parties here, which is
Who is the contract between, please?
the contract is between Cushman and Wakefield on the one hand, and the two parties here, Buffalo Water and Fidelity on the other hand.
Okay.
And the agreement is attached and incorporated into the complaint as Exhibit C. And frankly, the case really begins and ends with that operative agreement. Mr. Briansky says that the appraiser here is Cushman and Wakefield. And the disclosure obligation that he's urging on the court is a disclosure obligation on the part of Cushman and Wakefield as opposed to the individual appraiser. The contract belies his argument. There are three provisions that are precisely on point here. One is the prior services disclosure provision. It's the only provision in the contract that explicitly talks about disclosure. And it mandates disclosure explicitly. It's found at the record appendix at 123. It's part of the engagement letter. And it mandates disclosure of prior services by the individual appraiser, not by Cushman, but by Robert Skinner. And then it represents that the individual appraiser, namely the individual appraiser, the undersigned appraiser, has provided prior services during has not provided any prior services during the prior 3 years. So he's making a representation that he hasn't provided any services to the parties here. That's the disclosure provision. Mr. Briansky, neither today, nor in his papers, nor in his complaint, makes any mention of that, and I think that's telling. It's telling because that provision and that provision alone is fatal to his case. Then another provision, the provision that he harps on and that he relies on for his argument is the incorporation into the contract of the ethical rules of the Appraisal Institute. And he looks at Ethical Rule 3-6 in particular. But 3-6 speaks very specifically about the valuer here, which is a synonym for appraiser.
Is that defined anywhere in the ethical rules, what a valuer means, particularly this distinction between a corporate entity and the actual individual doing the appraisal?
Two answers, Your Honor. One is the author of these ethical rules, namely the Appraisal Institute that promulgated, wrote, and is the overseer of these ethical rules, has submitted an amicus brief to the court. And the Appraisal Institute has made it plain that the meaning of valuer within 3-6, and in fact, the ethical rules generally apply to individual appraisers and not to their firms, and for good reason, because it would lead to a nightmarish situation.
Can I ask, had they ever done it before the case? It's always nice when they've done it when it's not in sort of a battleground. Had they previously done it, or is it only in this amicus filing?
I frankly don't know the answer to that. Whether they have specifically given an interpretation. I imagine they have. I'm not familiar with it, but we really don't need to go outside the contract, because the contract itself, despite Mr. Briansky's protestations that the valuer here or the appraiser is Cushman, the contract itself defines the appraiser as Mr. Skinner. And what I would refer your honors to further conditions of engagement, which is found at Record Appendix 124, is part of the conditions of engagement. And it says the conditions of engagement attached hereto are incorporated.
Sorry, what page are you reading from?
I'm reading first from Record Appendix 124.
Right.
The provision that says further conditions of engagement. And then it refers to the conditions of engagement, which are found 3 pages later at Record Appendix 127. And conditions of engagement number 3 talk about the assumptions and limiting conditions that the parties should be aware of, that they certainly could have asked about, and that are specifically attached ultimately to the appraisal report. And so you then move to those assumptions and limiting conditions that are part of this engagement and that you see at Record Appendix 139. And the fourth line of the assumptions and limiting conditions takes all the guesswork out of this, because it specifically defines appraisers means the employee or employees of Cushman & Wakefield who prepared and signed the report. So it is defining the appraiser here, not as Cushman, but as the particular employee who prepared the report.
Did he sign the report?
He did sign the report. Mr. Skinner signed the report. And the certification of appraisal that Mr. Briansky makes so much of, which uses the word "we," is clearly a form which we don't know what the word "we" means there, but presumably it applies when more than one person is engaged in doing the appraisal. And in this case, Mrs. Skinner may well have had other people working with him on it. We don't know that. But he's the one who is making the certification. And it's clear that not a whole lot can be read into the word "we" as meaning anything other than Mr. Skinner and others who may have worked with him, because the very next page Record Appendix 142, talks about qualification of the appraisers, plural, namely we, and it says that that's attached as Addendum C. And when you look at Addendum C, the only person who's identified there is Mr. Skinner. He's the individual appraiser who's identified in Addendum C. So what Mr. Briansky and the plaintiff is really asking here is for a disclosure requirement, for this court to impose a disclosure requirement that goes way beyond anything that's demanded by the contract, anything that is required by the ethical rules, and anything that's required by applicable law. There really are three case dispositive, if you will, takeaways from the fact that the agreement defines the appraiser as the individual Mr. Skinner and not his firm. One is that to the extent that this court is inclined to extend the Elliott rule or change the Elliott rule in some way to apply to something other than real allegations of fraud, corruption, dishonesty, and bad faith, which there are none as to Mr. Skinner here, and only in a very conclusory fashion and not a good enough fashion as to Cushman. But if the court was ever inclined to extend that rule in some way to a concealment of bias or something else, or an appearance of bias, this is not the case to do it, because here there's simply no allegation whatsoever from which any reasonable fact finder could ever conclude that Mr. Skinner even knew about this so-called national agreement, was involved in it, was affected by it, had any involvement in it whatsoever.
I mean, all we know is it's not alleged. This is a motion to dismiss. We don't have record
That's true. That's true, and it's
to rely upon the allegations or what's not alleged.
that's right. And what's telling is the absence of any allegations that go to Mr. Skinner. What's also telling, frankly, is the conclusory nature of the allegations that that concern Cushman. I mean, for instance, we could, if this were, there are obvious differences between arbitrations and appraisals that the Elliott Court talks about, that we talk about in our papers. But even if this court were to treat this case as an arbitration matter and apply a lesser standard than the standard that's in place in Elliott, the fraud, corruption, dishonesty, or bad faith standard, were to adopt an evident partiality standard, more here, much more would have to be alleged than has been alleged. In fact, I would suggest, even as to Cushman, and Judge Sanders got it exactly right in that respect, because under the evident partiality standard, the partiality has to be evident. It has to be alleged. It has to be alleged with real particularity, so that in fact, the JCI Court, Judge Lynch in the First Circuit speaks to this. The Second Circuit in a case that Mr. Briansky relies upon, Applied Industrial Materials, speaks about this. Judge Van Gestel speaks about this in the Mass Mutual case that we've cited, and Justices Lenk and Cipher in an appeals court case, specifically the summary decision in Saputo versus Beverly Enterprises, which we also cite in our opinion, also talk about this. And they say, quote, evident partiality is more than just the appearance of possible bias. More than just the appearance of possible bias. In other words, more than what Mr. Briansky is saying, all of the case law somehow says is enough. Evident partiality, even in the arbitration context, which this is not, even when you're applying the lower standard, evident partiality is more than just the appearance of possible bias. Rather, quote, evident partiality means a situation in which a reasonable person would have to conclude that an arbitrator was partial to one party or one party to an arbitration. So
Let me step back a little bit for a few questions. With regard to the prior services disclosure, the undersigned appraiser has not provided prior services within the designated time frame. What do prior services mean? Clearly, he worked within the last 3 years.
yes, I think the only reasonable meaning of that is he didn't provide prior services to either of the parties or with respect to the particular property at issue here. And there's no suggestion that he did.
Okay, so
And if he had, that would be an issue.
I was going to say, if he had, would that fall into the fraud in the inducement argument, that arguably if you represent things which are false and people enter into an agreement for an appraisal, would that arguably invalidate the appraisal if there was a claim of fraud in the inducement?
If Mr. Skinner had in fact provided services to Fidelity in the last 3 years, or had in fact, provided services to this property, or had a personal interest of some sort, personal interest in this property, conceivably that would be, and he didn't disclose it, that would fall within Elliott. That would be dishonesty on his part. That would be bad faith on his part, potentially even fraud, given that the contract is creating a duty on his part to make that disclosure.
Now, of course, the appraisal rule is common law and the arbitration rule is by statute. I don't think the arbitration rule speaks of bad faith, does it? I don't think the statute speaks of bad faith.
I don't know. I don't think it specifically uses the term bad faith.
What is, if we define bad faith, would that not include evident partiality?
In certain context, bad faith could include evident partiality. But it has to arise in a context. I mean, we're talking about an appraisal context where the parties really have a real interest in finality. The entire real estate market depends on that sort of finality. So that in that context, there has to be allegations, again, from which a reasonable person would have to conclude, particular allegations would have to conclude that the person is acting in bad faith, is doing something wrong, is partial to one side or another. It has to be evident. That simply is not here.
Can I ask how that works when we've also got this claim of the breach of the implied covenant of good faith and fair dealing? It's sort of an awkward mixture. We've got a very low standard, and then we also have a breach of the covenant of good faith and fair dealing. So how do we analyze that claim when we're dealing with an appraisal contract?
Well, the claim for a breach of the covenant of good faith and fair dealing arises out of a separate contract, arises out of the option agreement.
Okay.
And so there really has to be, within the option agreement, an express obligation of some sort on the part of Fidelity in selecting an appraiser to make some sort of disclosure. There's no, there's no obligation like that on the part of Fidelity.
I'm just trying to understand. The ethical rules are built into the letter, right? And there's an obligation, at least on the value word, to behave ethically here. And I'm just trying to understand. So the covenant of good faith and fair dealing, you say, can't transform this low standard for the appraisal, right?
Oh, it certainly can. Certainly cannot.
So Elliott has this very low standard, fraud, corruption, dishonesty, or bad faith.
I'm not sure you're using the word low. I see that as an extremely high standard.
Well,
that is in.
It's
that
not.
has to be
It's
played
not.
with
It doesn't use the
particularity,
word.
Otherwise,
doesn't
parties
use the
don't
word,
get into court.
Doesn't use the word good faith. It uses the word bad faith, right?
Right.
So, but we don't. we don't read in a good faith and fair dealing requirement into that standard? Is that right?
That's right.
And so how do we analyze the good faith, the breach of the covenant of good faith and fair dealing when there's no good faith requirement in an appraisal context?
I think that you have to read, what Fidelity's obligations would be under the option agreement.
So there's no good faith, there's no obligation to act in good faith, just the absence of bad faith, right?
Is absence of bad faith with respect to the appraisal agreement. With respect to the option agreement, arguably there's, in the abstract, or arguably there's there's an implied covenant of good faith and fair dealing. And to the extent that, for instance, I could imagine if Fidelity, in selecting Mr. Skinner, knows that Mr. Skinner is lying, and that Mrs. Skinner has in fact provided services to Fidelity or with respect to the property or as a part owner of the property and doesn't disclose that, and Fidelity doesn't disclose that, that would arguably be a breach of the implied covenant of good faith and fair dealing. But we don't have anything close to that here.
All right, thank you.
Thank you, Your Honors.
And we'll take our morning break.